Okay, welcome back, everybody. We're going to take another break from those replays from the Dalia DiPolito case in Florida. Again, she was convicted, she was sentenced, but there are a lot of appellate issues to deal with in that particular case. We know that the state has filed for sanctions against the defense attorney for the way a psychological examination of the defendant was ultimately not done according to schedule, wasting some time and money on the state's behalf and on an expert's behalf who was called by the state. And so that issue is outstanding, and we're also waiting for the appeals themselves to grind forward. So lots going on in the DiPolito case after the verdict was rendered. We're going to continue our discussion about the Confederate monuments that we've been having across several days here on the LawNewz Network. Would like to introduce you all to a friend of mine from law school, actually, Amanda Nelson, who's an art law attorney practicing in New Hampshire. Amanda, good to see you here on the LawNewz Network, and not as a competitor on a law school exam.
Good to talk to you too, Aaron.
Okay, so you practice art law, and one thing that I don't think has been discussed very much, but which your whole world surrounds, is the question of, okay, well, do artists who create statues have legal rights to protect them from being ripped down either by the government or by protesters? And the answer is sometimes, which is not a really clear answer, but that's what this boils down to, right?
Absolutely. And interesting enough, starting in 1990 is when the federal government put in the Visual Artists' Rights Act. And it protected a visual work of art like a statue starting in 1991. But it was not retroactive. So what that statute did, let's not confuse statute and statue, is that it basically said artists have certain rights in their work, and we would call these moral rights. It's a concept that is very common in Europe, but is not very common in the United States. And basically it means that an artist has a right to their work not being destroyed or mutilated or things of that nature. Again, though, it only applies to art that was created after 1991. So these statues that we're talking about, which were put up in the 1920s, the 1950s and 60s, are not covered by this.
Well, it's certainly interesting because, as we were just talking about with LaDawn Jones, many of these statues, they weren't even put up directly following the Civil War. It's not like they were put up by people to remember their comrades in battle. They were put up in other points of U.S. history that sort of have their own meaning. And so, bottom line, no federal protection under that particular law, but I did a little bit of digging as well that I think I shared with you about different states are now passing laws to try to retroactively protect these statues. North Carolina passed a law in 2015. Alabama's got a law in 2017. Mississippi, Georgia, Virginia, they also have specific laws on the books. And the Virginia one is kind of an interesting one because we just had this incident in Charlottesville. That one says it's illegal to disturb or interfere with war monuments or memorials. And part of what was going on in Charlottesville is people were suing to try to get the city to remove it, or I should say the protesters were asking for it to be removed, but then there was a counter lawsuit saying the city didn't have the ability to remove it because the state law superseded the city's ability to oversee a monument, kind of what I believe was on city property. So it seems like the states are trying to continue this legal tangle well beyond the federal law that you were talking about.
Absolutely, and it's not unusual for states to have specific laws on the books to protect art and artists. And so even if there's nothing necessarily at the federal level, the states themselves might have something, or even the towns and cities might have specific ordinances on how they're going to handle public art. And so, for anyone who wants to go out and say, hey, let's tear this down in the middle of the night, there could be civil consequences that they're not necessarily aware of.
Yeah, exactly. Now, what are some of them? I know that you were talking about a situation with public art up in your home state, New Hampshire, where there's an issue going on that's got nothing to do with the Civil War monument, but it's illuminating as to how some of these municipal ordinances work in this area.
Absolutely. So what's going on in New Hampshire is there's a U.S. post office that in the 1950s had a bunch of murals put in and depicting various pieces of history throughout the town. One of the murals depicts a Native American crouching outside of a colonial home. New Hampshire, for those of you who are not aware, very much had violence and skirmishes between the colonists and the Native Americans who were living here, resulting in massacres on both sides. And this mural was designed to sort of memorialize this hardship that the colonists had to face with the Native Americans. And a group wanted it taken down because they said it was racist. It portrayed Native Americans in a bad light. Another group came forward and said, hey, wait a minute, this is depicting an accurate era of history. It should stay, but maybe we need to put a little placard on it or something to describe what's going on here. There were a lot of town meetings going back and forth where they were discussing what to do. And what was actually amusing was the town punted on the question and said, it's the U.S. Post Office. We have no jurisdiction over them to tell them what they can do with their murals. And so they were able to kind of duck that situation. But those conversations went on for quite some time as to how do you reconcile what one group sees as one thing and another group sees as something else.
Yeah, and so the bottom line is, in that case, the municipal ordinance didn't provide a very strong framework, but in most cases they do. So if you were advising someone who is either the creator of a statue or perhaps is a descendant of someone who created a statue, your work would be cut out for you, because you'd be digging all the way through municipal ordinances, trying to see if there's a state law that protects it. The visual artist rights law that you talked about at the federal level would not apply. So I think you'd be in the weeds for quite a while on this.
Absolutely. And actually, if a statue were made today and put up, the Visual Artists' Rights Act would apply. Because it would be after 1991. Clever municipalities will try and get artists to waive that and say, we can do whatever we want under this contract. And that is something that if it was my client, I'd warn them to watch out for and say, this is what the effect of this is if you want to waive this right. That it gives the town or the municipality the opportunity to take it down, remove it, destroy it, and that sort of thing. And do they really want that?
That's interesting. I mean, I would certainly advise my client of that, and then I turn around and say, well, if they want you to waive it, then maybe they should pay a little bit more for the work,
right.
or put a clause in that if they are to get rid of it, then you're giving them the right to do so, but then they would have to give it back either to the artist, him or herself, or perhaps to a descendant or something. I mean, there would be some kind of a bargaining room for it. And we're seeing that in so many of these cases of these Civil War statutes. The ones that are being removed by legislative process, either through a city council or a county government body or even a state legislature, a lot of times they're being taken out of a prominent public park and being moved to, for instance, a museum. They're not being outright destroyed. Some of them are not. They're just being taken down from that, position of prominence up on a big pedestal in front of the State House or the courthouse or City Hall or whatever you call it. So that may be the result of either some good lawyering or just a recognition that, well, okay, even if we don't like the message, they are art, okay, which few people have been arguing recently. And it would seem that they're at least recognizing that.
And art is in the eye of the beholder. I mean, that is why the Supreme Court has said over and over again, we are not in a position to define what is art. One person sees as art, another person may say, my 5-year-old did this and I put it on my fridge. I don't get it. So we have to be very careful when we sort of say what is and what isn't art. Because, again, it's in the eye of the beholder, and that's kind of where the Nazis went in the 1930s and 40s, was they sat down and said, we don't like this art, we're going to call this degenerate art, and we're going to destroy it. And I think a lot of people would look back on that period and say, we don't agree with that.
Well, I think that the historical lesson there is probably a wise one. Is that the specific reason why our government policy is not to really question the aesthetic quality of the art? If somebody calls it art, they just say, okay, then it exists, there it is.
Absolutely. And in this country, it really is the market forces that will determine what lasts and what doesn't.
Not only that, but art isn't per se named under the First Amendment, but it's so tightly wound with it that it's almost impossible to separate the two.
Absolutely. I mean, the whole purpose of the First Amendment is expression. And what better way than to create art is expression?
Yeah, certainly. You know, a picture's worth 1,000 words, and it probably is worth more than that. Well, I appreciate your perspective on this. Amanda Nelson, a law school friend of mine who practices art law as a profession. If you are an artist, then there are attorneys just for you, the same as with any other profession. Good to see you here on the Law News Network, Amanda.
Same here.